Alright guys, welcome back to the channel. Today we're looking at a sentencing hearing out of Texas. And this one's a wild ride because the defendant, Hank Maldonado, already took a plea deal. But the state is not happy about it. So here's the setup. Maldonado is facing 2 felony cases, both with a plea of no contest. Under his plea bargain, the punishment is capped at 12 months in a state jail facility, and both cases would run concurrently, meaning at the same time, not back to back. Sounds simple, right? He took the deal, the cap is set, so the judge just has to rubber stamp it and send him on his way. But that's where it gets messy. The state stands up and says they're opposed to this deal going through easy. Why? Because according to the pre-sentence investigation report, Maldonado has 3 arrests over 10 years, involving illegal substances, and he's still claiming he doesn't have a drug problem. On top of that, he's got a history of just not showing up to court. He skipped a court date back in 2023, and he was actually revoked on a previous case and sent to prison for 2 years because of it. Now his defense attorney is going to step in and try to paint a different picture, claiming his client doesn't have a serious drug problem at all, that he has a stable business with his wife, and that the reason he missed court wasn't defiance. It was pure fear of going to prison. So now the big question is, does the judge stick to the 12-month cap from the plea deal? Does he go even lighter and give probation like the defense is asking for? Or does this judge, who's clearly not thrilled with this guy's track record, decide enough is enough?
Court is calling 2024 CR 2071 and 2024 CR 007676 State versus Hank Maldonado. Can I have parties announced?
Andrew Harris, Animal State.
David McLean for the defense.
And are you Mr. Maldonado?
Yes, Judge.
In each of these cause number, you entered a plea of no contest. According to your plea bargain agreement, and each cause number, punishment is to be assessed at a cap of 12 months in the state jail facility. The state is opposed to your application. The cases will run concurrently. The state is taking in consideration 2024 CR 1039. Have both parties had a chance to review the PSI report, state?
Yes.
Defense?
Yes, Your Honor.
Any objections to the PSI report, state? Defense?
There you are.
All right, state you're opposed. Why?
Reading the PSI, it seems that Mr. Maldonado is still in denial about certain things. The first is his history of drug use and whether that constitutes a problem. While I am not qualified to say whether someone is addicted to substances or not, it does seem to me that 3 arrests over a period of 10 years for illicit substances, 1 case leading to a person being sentenced to confinement, seems to be serious negative outcomes that the persistent engagement in those behaviors would seem to indicate an addiction. Mr. Maldonado does not seem to have a good track record of appearing when he is required to do so. His previous controlled substance case, he was ultimately revoked and sentenced to 2 years for the resisting and evading cases for which he is still pending. He failed to appear on December 1st of 2023. So going back to 2011 or going back to 2023, Mr. Maldonado seems to have an unfortunate tendency to not take his commitments to the court seriously. And based off of that history, it doesn't seem like he's going to be any more committed to meeting these requirements today.
All right, defense?
Your Honor, on behalf of my client, I reviewed the PSI and the TAP. The TAP evaluation seems to indicate that he does not have any kind of serious drug or alcohol problems. They were recommending basically urinalysis, not even an outpatient program. I think he's addressed those issues. In all candor to the court, we had a PSI set for Mr. Maldonado, and he did not appear, and he did take off for quite some time. I've talked to Mr. Maldonado about it, and he is basically just terrified of going to prison. That's really what it boiled down to. And with kind of this opposed type of offer, he was very nervous about coming in. And some people have a fight or flight, and he took off. And I I tried, Your Honor, to get him back in. And it was just something that he was just too afraid to face. And that's just being honest with you. I think he could be successful on probation. I do. He's got a business. He works with his wife. I think it's something that he could be productive. He hasn't gotten in trouble while he's been out, which is not an excuse, but it is at least something where he's not just going out and reoffending again. We would ask the court to at least consider the application for deferred and place him on probation.
All right, Mr. Maldonado, you were scheduled to appear for court. You did not appear. That's a sign that you won't be a good candidate for probation. I'm looking at your criminal history, and you have a burglary of a vehicle from 2011. You were sentenced to 80 days in jail. Then you had a possession of marijuana, which I understand people see that differently now. That was dismissed because you were convicted of something else, which tells the court that it was taken in consideration. Then in 2011, you had a possession penalty group 3, 28 to 200 grams. You were placed on deferred adjudication for 4 years out of the 186th District Court. Probation was revoked and you were sentenced. They amended it and just sentenced you to 2 years in the prison. And then in 2023, you had another case, book dismissed. And then you had these 2 cases that you were set to appear before the court and you failed to appear. How old are you?
33.
So you're 33. You're not a teenager. So why you would steal someone else's vehicle or use it without permission is beyond the court's understanding at a person your age. In each cause number, the court is going to find you guilty, sentence you to 12 months in the state jail facility. The cause numbers were run concurrently. Taking consideration 2024 CR 1039.
I apologize for interrupting.
Yes.
Is there already a dismissal form on file for that cause?
I'll have to have the clerks look and see.
What was that case number again, Judge? I'm sorry.
It's 2024 CR 1039. In each cause number, there's to be restitution and no contact with Richard Anthony Johnston and also Felix Francisco Citero Rivas. And I recommend the therapeutic community. He says he doesn't have a drug or alcohol problem, but there has to be something wrong with you, or either you're just someone who likes to steal and take what doesn't belong to you. Did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal in each of these cause numbers?
Yes, I did, Judge.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, I did.
All right, and it probably would have been in your best interest. Well, not probably. I know it would have been in your best interest to have appeared on your sentencing date. Who knows what would have happened if you would have. All right, good luck.
Okay, so let's break down exactly how this played out. First, the prosecutor, the state, laid out their case for why they were opposed to an easy deal. Their main argument was that Maldonado is in denial, specifically about his drug history. The prosecutor pointed out that 3 drug-related arrests over a decade, with one of them landing him actual prison time, is a pattern that looks a lot like addiction, even if no one's officially diagnosed him. On top of that, they brought up his history of missing court dates, going back to 2011 and as recently as December, 2023, arguing this shows he doesn't take his obligations to the court seriously, and there's no reason to believe today would be any different. Then the defense attorney got his turn. He told the judge he'd reviewed both the PSI report and a TAP evaluation, and according to that evaluation, Maldonado didn't actually have a serious drug or alcohol problem. The recommendation was basically just urinalysis testing, not even an outpatient program. As for the missed court date, the attorney was honest with the judge. He admitted his client disappeared for a while, but explained it wasn't defiance. According to the attorney, Maldonado was simply terrified of going to prison, had a fight or flight moment, and picked flight. The attorney said he personally worked to get him back into court, and emphasized that since then, Maldonado hasn't picked up any new charges, runs a business with his wife, and could be successful on probation. He asked the judge to consider deferred adjudication or probation instead. Then it was the judge's turn, and this is where things got serious. The judge went through Maldonado's full criminal history out loud. A 2011 burglary of a vehicle that got him 80 days in jail, a marijuana possession charge that was dismissed but factored into other sentencing, and a 2011 drug possession case where he was placed on deferred adjudication for 4 years, but that probation was later revoked, and he ended up serving 2 years in prison. The judge also pointed out that Maldonado is 33 years old, not a teenager, and said it was beyond the court's understanding why someone his age would still be involved in stealing or using someone else's vehicle without permission.